I want to have a proper discussion of the terms and conditions of the terms of engagement of the lower bench and the staff. That is something that I will make my personal project.
Thank you very much. Yes. Any more questions?
Chairman, that will be all for now. Thank you very much.
Well, thank you. You said that will be all for now. I believe you won't have the opportunity to ask questions again. We are now moving to the leadership. And I'll plead with the leadership that the 3 questions rule would apply to us as well. So, Honorable Majority Leader Mama Yariga, you have the floor.
Thank you very much. Let me also congratulate the nominee, Acting Chief Justice, for his nomination to occupy the position substantively. I'm sure you sat through and you listened to the engagements between myself and the minority side. I had no intention of preventing anyone from freely expressing themselves. I just wanted them to do so in accordance with our rules, so that there can be sanity in the way that they sat here and asked you, because I know you are very capable of providing them with a response, is that they question whether it is proper for you to be taken through the vetting process, because there are a number of suits pending challenging the removal of the previous Chief Justice. They're asking what the implications for the propriety of the removal of the previous Chief Justice succeed in their claim. What will be the nature of the enforcement of the reliefs that they are seeking, and etc. So basically, the question is, do you think that it is proper for us to go through this process whilst these suits are pending?
Thank you, Honorable Chair. I think yes, it is proper. That is the first basic answer. It is very proper. It is a constitutional duty that Parliament is performing. And as at now, there is no order from any court of stopping you from performing your constitutional duty. The President has nominated somebody for Parliament to vet the person for the appointment to the position of a Chief Justice. Vetting of the nominee is a constitutional duty imposed by you by the Constitution. It's a duty imposed on you by the Constitution. So if you have to perform it, nothing, and I think absolutely nothing, stops you from performing your constitutional duty. You see, in the years gone by, when cases like Baffoe versus the Bank of Ghana, which I authored, actually, were written, the learning was that, and the practice actually was that when an application for injunction, or when there's an application for injunction is pending, then you hold your hands. So there were situations where persons will rush to court to file a writ or file an application for injunction, and if you go against, even without any order from the court, you went ahead to do what the injunction was being sought for, then you'll be cited for contempt. And cases like Baffoe versus Bank of Ghana, Sito, and other came up and said that that was right. That was it. But the learning now, particularly Vincent Assefuwa versus the Attorney General, I mean, it's an unreported case. It was done fairly recently. The learning now is that constitutional duty to be performed until and unless there is an order from a court of competent jurisdiction. Constitutional body is performing such a duty just because somebody has filed an application for injunction or even a writ. Even the application of injunction, for two things went side by side until the 29th of August, when the court said the matter was ended in favor of the sitting president, so he should continue. And he did continue. If the courts had come to the conclusion that it was the judgment should go the other way, that would have been the order of the Supreme Court, and it would have been 1-2. The same thing would have happened in 2020 when there was this petition. People are even, some persons are even of the view that even the Supreme Court cannot even come to the Parliament and then make an order to stop a constitutional duty being performed. But that is another matter altogether. But for as long as no order has been made by any court, a constitutional duty will have to be, can be performed. And I think it is right that we are going ahead with the vetting.
So in essence, there's no court order restraining the president from nominating a Chief Justice. There's no court order restraining Parliament from processing the nomination of the president.
There's no court order.
And you are here because we have summoned you to come for us to process you.
Which I couldn't refuse to.
Of course, you cannot refuse our summons. You cannot refuse our summons. But the second issue that they raise, and I want to be fair to the records, is that they also say the cases that have been filed, you are sitting now as the acting Chief Justice, and that you haven't listed those cases to be heard. Is that accurate? And why would that be the case?
If this statement is made by, with all due respect, I don't know whether it is parliamentary language.
Yeah, they made it here.
If this statement is made by a person who is not a lawyer, I will put it down to ignorance. I will say that maybe the person is uninformed about legalities, so I will pardon. But if a lawyer makes a statement like this, I would think that it is populist and maybe downright mischievous. The Chief Justice does not list cases, and please, my words, the Chief Justice does not list cases for hearing. The Chief Justice empanel judges to sit on cases that have been listed. Cases are listed when they are ripe for hearing. So we have listing, we have cases getting ripe for hearing, and then being listed before the empaneling is done. The Chief Justice comes in after a case is ripe for hearing and it has been listed, and then he empanels. So the Chief Justice cannot be accused of failing to list cases or empanel, when the case is not even ripe for hearing. A case is ripe for hearing when pleadings have closed. Pleadings get closed with it. Pleadings are a response, and then even sometimes we ask you to file memorandum of issues, particularly constitutional cases. Things are done, and when they are done, we say the case is ripe for hearing. Then the registrar will list the case, list all the cases that are ripe for hearing, and the Chief Justice will then empanel judges to sit on them. So if it has not been brought to the attention of the Chief Justice that these cases are ripe for hearing, or they are listed, the Chief Justice does not empanel. Now, when a plaintiff issues a writ, and then he's waiting for the defendant to file a response, a defense, there is a time limit within which the response has to be filed, the defense has to be filed. The plaintiff knows this. So if within that period, the defendant doesn't file a defense, he has every right to move the court for certain reliefs. But before he can do that, he goes to the registry to make a search to find out whether a defense has been filed. If he finds the defense has not been filed, then he can go ahead and then move a motion for judgment in default or whatever. But that is what a diligent plaintiff does. So if a plaintiff issues his writ, and then he's told that it has been served, and so the defendant is supposed to file his defense within this period, then he goes to sleep, waiting for the case, the defendant to file, and he doesn't file, and then the defendant now comes with application for extension of time within which to file defense and all that. The defendant, the plaintiff, who at this point in time may be described as being indolent, cannot be heard to say that the Chief Justice is not empaneling. The Chief Justice doesn't, seriously, but for the social media phenomenon in the social media where lawyers put writs in the social media, the Chief Justice may not know of any case, we may not know that any case has been filed until it is listed and he empanels. So he may not even know that somebody has filed a writ, somebody has filed a defense, or somebody has filed anything. But these days, because of social media, some lawyers, even before they file the writ, they put it in the social media. That is what, but that is not official. A Chief Justice cannot start empaneling, assuming it came into the papers tomorrow, that these cases have been, they are ripe for hearing. The Chief Justice cannot, on that strength, empanel judges. The Chief Justice doesn't deal with the social media that way. So if any lawyer, worth his salt, makes a statement to the effect that the Chief Justice is not empaneling persons to sit on a case because of something he stands to gain, it is rather mischievous. Then it is tagged with, the statement was that the chief was in a hurry to empanel persons to sit for injunction. When you file an application for injunction, you are given a date. The return date is there. So it is ripe. So it is ripe. when you file an application for injunction today and they fix it for, let's say, a week's time, what the registrar is saying is that the respondent will be served immediately and then he has to respond all within that time. So when the Chief Justice gets the application, he starts empaneling based upon the return date. So it's not as if the Chief Justice is in a hurry to empanel for applications, but wasting time or refusing to empanel for substantive rates. The substantive rate is not ripe for hearing. It hasn't been brought back to attention, and I cannot empanel judges for that purpose.
Thank you very much. I think that I'll convey this teaching and procedure to the minority. I'm actually asking the questions on their behalf, just so that they see that we're not running away from anything, and we're not afraid of anything. I mean, and that was what I kept telling him, that the same issues that you want to do press conference and not give the person the opportunity to respond. Sit here and ask the person, and he will give you answers, because I'm sure he's capable of giving you answers. And so I've asked all the questions, the critical questions that was the substance of their statement. And clearly, if they were sitting here, they would have seen that they really have no basis. And, you know, at most, clearly a populist gimmick. My Lord, you were involved in this case of Adomako Anani versus Nana Owusu Agyeman. I think you, Justice Wood, presiding CJ, Ansa, Yeboah, and then Akamba. What is interesting is what Justice Wood said, then CJ, that the often quoted legal maxim, justice delayed is justice denied, coined by the British politician William Gladstone, is no mere cliche. The right to fair trial is in a timely manner is neither a courtesy nor a favor, but a fundamental right. Protracted delays in the administration of justice impact negatively not only on those who assess the courts, such as the victims of crime, accused persons who are acquitted at the end of their trial, parties in civil proceedings and their privies, lawyers who practice before the courts, but indeed the entire justice system. The judicial history of this relatively simple family-related land matter, which was commenced in the High Court, Kumasi, as far back as the 4th of April, 1974. 1974 provides an insight into the harmful effects of systemic delays in the administration of justice. Regrettably, it has taken 40 long years, a whole generation, for this case to finally find its way into this court, the court of last appeal. We hope court business shall always be managed in ways that will not occasion a repeat of this parody of justice. So this is a case that lasted 40 years. It was a simple family land matter, and you were part of the case. Today we're still talking about delays in the administration of justice. In this age of AI, have you considered how to use technology to quicken the pace of the administration of justice and the resolution of cases?
Thank you, Honorable Chair. I have forgotten the facts in this case, but I mean, you are not even asking me about the facts of the case, actually. But were there any dissents?
There was no dissent. It was a unanimous, I think, decision of the court.
Yes, I mean,
the court was happy that they had finally resolved the matter. It was basically a land matter, But what really happened was that the judges at the High Court kept changing.
Yes.
And so the issues were whether or not, in the light of the changes in the judges, whether the proceedings of the previous judge should just be adopted or whether or not the case should start afresh. And the judges just kept being changed until finally the matter went to Court of Appeal. And so it just lasted 40 years. That's the most important thing, that this case lasted 40 years.
I get honorable Chair. I think this is not an isolated case. I mean, it is far. I mean, I will. But what honorable member means is that it lasted for so long. Yes, I remember I had been cases like that. And I remember there was a time the Honorable Chief Justice.
So basically, my Lord, let me just go straight. The question is what are the mechanisms you think? You've said a lot today about how to deal with, ensure speedy trial and etc. But there are structural issues. We have about 5 layers or 4 layers in most cases. When cases start from the lower courts, go to High Court, then to Court of Appeal, to the Supreme Court. That's about 5 layers, okay? Now, can we just reduce the layers? Because the layers mounting up to 5 do not automatically guarantee quality outcome.
Yes, I mean, Honorable Chair, I agree with you. But it all boils down to the rules. It all boils down to the rules. The Constitution gives a person a right of appeal all the way to the Supreme Court.
So can we change the rules and say we are giving you just 3,
Yes.
attempts to get justice?
Yes.
And if at the 3rd attempt you are not satisfied, you just have to live with that and rather work on the quality of the courts so that, by the time you do 3, anybody looking at the outcome at the 3rd layer can confidently say that what you've really gotten is justice, so you can't waste our time and resources. Yes. Can't we just cut down the number of layers?
That with all due respect, that would be the role of it will be your mandate.
Yes, so because some of those provisions are entrenched in the Constitution. So these are issues that I've raised with the current committee that is working on the Constitution review that I think that we should cut down on. And then also, can we say that the Court of Appeal should be the highest appellate body whilst we have the Supreme Court actually serve as a constitutional court?
Absolutely.
Because there's too much caseload at the Supreme Court level,
Absolutely.
which has necessitated the appointment of so many Supreme Court judges. Because I'm even advocating for a panel to sit in Bolgatanga near Boku so that I don't have to travel far to have access to justice at the Supreme Court level. Can we just transform our Supreme Court into a constitutional court like the US, like South Africa has? What's your thinking? In view of the discussions going on about...
The Honorable Chair, this is a very interesting trajectory that this question is taking. People, in answering your question, we'll have to sway into why the Supreme Court, whether the Supreme Court even needs that number of judges. And it has been said in several fora that I have been, that whether we have a Supreme Court of 10, like 9, like America, or we can go to the minimum of 1 plus 9, that is 10, as our Constitution provides, and not go up. It's dependent upon the jurisdiction of the court, the Supreme Court. as you rightly said, in South Africa, they have a Supreme Court and they have a constitutional court. In America, all the states have their Supreme Courts where cases civil cases or whatever, can go all the way to their Supreme Court. But when you come to the Federal Supreme Court, it is for constitutional cases alone. Now, in Ghana, we have 7 different kinds of jurisdictions. Each one is as heavy, carries as heavy load as possible. We have supervisory jurisdiction, we have appellate jurisdiction, we have original jurisdiction, we have jurisdiction to deal, review jurisdiction, we have appellate jurisdiction as far as the chief justice matter is concerned, and we have jurisdiction to deal with presidential, and then we have supervisory jurisdiction. So we see at every point in time, and the Supreme Court is made up of very old men like us. So you see, even one of the very first things that every Supreme Court judge, one of the very first things that you say when you get to the Supreme Court is, hey, I thought I was coming to the Supreme Court to relax, not knowing that this place is even busier than the Court of Appeal. It is a statement made by everybody who has passed through the Court of Appeal. The Supreme Court is so inundated. As you are aware, there is a criminal case, Ali Kasina, started in my village at Goso, and it ended up at the Supreme Court. We have cases, civil cases involving land, and it starts from the Circuit Court to the Court of Appeal to the Supreme Court. We have magistrate court cases from the magistracy traveling all the way to Supreme Court, and we sit on them. So this is where the problem arises. There is no way you can have, if you decide to stick to the 10 persons, you have only a panel of 2 panels, and only 1 panel when it comes to constitutional cases. So you can't deal with all these cases. And believe you me, because of the rights attached to, have been granted by the Constitution that a person has a right to go all the way to the Supreme Court, people are prepared to, and now, see, now it's even easier. The Court of Appeals are all over. In the years gone by, people will think twice if they have to come to Accra to do appeal cases. Now the appeal courts are right in their region. So they will file their cases there. Then if you are doing a case, the slightest thing that anybody does, interlocutory appeals, you are going to the Court of Appeal. So when it comes to personnel, it is difficult to, as it were, say that numbers should be reduced when it comes to the Supreme Court. Now, your case, the case that you have mentioned, if you look at it properly, if you read it, you realize that it spent, if it was 40 years, it took 40 years for it to be finally addressed. You will find that about 35 of that number of years happened in the trial court. When the cases that come to the Supreme Court, appeals don't take up to 1.5 years or 2 years. The Court of Appeal, they say it. The simple reason being that by the time it comes to the Court of Appeal, by the time it comes to the Supreme Court, then we already have the bulk of the record of proceedings prepared. And then at the Court of Appeal, it is written submissions, just the written submission of the parties and then the ruling. That is added for it to go to the Supreme Court. So preparing the record of proceedings doesn't take so long. But at the trial court, one, because of the number of changes in terms of judges, and then in the years gone by, parties had the right to object, to say that, no, in the years gone by, both parties and the lawyers had to agree for the proceedings to be adopted. If one of them says, no, I don't want the proceedings to be adopted, then it has to be started de novo. And then even where, finally, even where proceedings were supposed to be adopted, you'll find that the judge might have retired, and there are some judges whose handwriting only they could decipher. I mean, some judges were writing like this, like that. So you find that they cannot, nobody can even read their handwriting to be able to type it. So in the long run, they have to start de novo. And so if a case goes through 4 judges, you know, that one alone is enough. But as I said earlier, there must be a way of tracking cases so that cases that kept so long on the way should be fished out. In the time of Justice George Wood, I remember she caused some judges, some cases to be selected. There were about 20 cases selected. And he selected some judges. I got 3 of the cases. And these were cases that had been on our books for so long, like this. You see, when they were cases were given to me, in one particular instance, a file as big as this. It was scary, but I tried to take my time. I had been assigned by the Chief Justice. I tried to take my time to, as it were, arrange the processes to filed. By the time I got to the end, the file was as thin as this. This file, which was more than 100 hearing notices, more than 100 hearing notices, all piled together like that. So by the time I selected the statement of the writs, the statement of claim, the defense, and then what did they call it at the time? Application for directions, with a very thin file to go on. Then one of the things that also lead to delays is the lawyers. When I was in practice as a junior, if there is a case that is going on appeal, and it is time for you to settle records, your senior sends a junior to go and tell the registrar the things that should be included. But now, lawyers don't go there. They set their clerks who go and tell the registrars everything. So everything should go into the record of proceedings, the compilation. Somebody has filed a writ at the High Court. In the course of the trial, he has filed an application for injunction, to which he attached so many copies of other documents. And then there was a response. They heard the matter, there was a ruling. that was an interlocutory injunction. The case has ended. It is going on appeal. If you are prepared the record of proceedings, do you need to include the application for injunction and all its documents? But all these things will be included, making a very bulky record of proceedings, and it is the clients, for the parties who pay for the record of proceedings, and each record of proceedings, each page is sold at a price. So you find somebody's record of proceedings, about 7 volumes. You decide to go through it, and you can actually reduce it to about 3 volumes. Particularly in this day and age where we file witness statements. So all these things add to the delay, transmission of records, and all that. But I must admit, 40 years is over the top. And if AI can help us trace this, we have to, whatever we do to get AI to do it, we should do it.
Thank you very much. I want to congratulate you once again for your nomination and to indicate that your responses have been very illuminating. Thank you.
Thank you very much.
Thank you, Honorable Leader. It's now the turn of my Vice Chairman, Honorable George Kweku Rickett Hagan. You have the floor.
Thank you very much.
More than 3 questions.
Thank you very much, Mr. Chairman. My questions are actually 2, just a view. My Lordship, Paul Baffoe, congratulations.
Thank you very much.
Looking through your CV, I have no doubt in my mind, looking at your background, knowledge, and experience, I have no doubt in my mind, and I believe many Ghanaians, that you are the right person for the job at this time.
Thank you very much.
Now, just as I said, just a view, actually, that I want through the bar. Thank you.
Thank you, Mr. Chairman. Honorable Chair. I think I don't agree, I don't share that view that we are churning out too many lawyers. Actually, the word churn, we are not training, we are doing substandard work by that the products are not substandard. But that is not the case. We are also not overproducing. Actually, you see, if you go into history, throughout the whole period that we have had lawyers in Ghana, lawyers that the law school has produced, and the lawyers who have come from outside, all put together from 18th century, Mensa Saba and all that, we're not up to 15,000.